Section 43, Grant of Patents. So far we have seen what happens to a patent application once it is filed by an applicant, the various stages of prosecution, there is publication, there is examination of the application, there is also a new type of examination, expedited examination, and we saw the stages in examination. The controller allots the file to an examiner, the examiner files his report to the controller, which has to be confidential. Based on the report, the controller issues the first statement of objection to the applicant. The applicant, if it is required, justifies or tries to get over the objections raised by the controller, which can happen for some time, and it eventually results in the grant of a patent. Or the controller may, under section 14, call for a hearing if there is an adverse finding given by the examiner, and he can also have a hearing under section 15 where he may either refuse the application. If he finds that the patent need not be granted, he can have a proceeding under section 15 wherein he may refuse the application, amend the application, and grant the application once the objections are corrected. So, the grant of the patent is the point at which the application becomes an enforceable right. Till the grant of the patent is not enforceable. A person will not be able to file a patent infringement suit till the grant, and the grant is the proof of a right. The fact that the applicant is now entitled to a patent right and is entitled to exercise his rights that are guaranteed under section 48, they all start with the grant. He cannot exercise any of his rights, that is to exclude people from making, using, selling, offering for sale and importing the invention before the grant. So, the grant is a point at which the rights accrue in a patentee. We saw there are certain instances where an applicant will have rights like that of a granted patentee. We saw that under section 11A7 there are certain instances where some rights an applicant will have even before the grant, and we also saw instances where a patent is made ready for a grant but a secrecy direction is issued, though a patent has not been granted, can expect some benefit from the central government, say in the form of a solatium, as though a patent has been granted. So, there are some deeming provisions where even before the grant the applicant can enjoy certain rights as if a patent has been granted, but largely the rights of a patentee accrues on him only at the point of grant. So, section 43 is important for us to understand the scheme of things, because 43 is the point of grant. A grant happens under 43, but it may happen under different provisions. Say if there is an opposition filed under section 25(1), the applicant gets over the opposition, it is granted as soon as the opposition is dismissed. So, a 25(1) proceeding could lead to a grant. The controller calls for a hearing under section 15, the controller raises certain objections, the applicant gets over the objections, the controller may suggest some amendment, the applicant amends the patent and it gets granted. So, there could be a grant pursuant to section 15, there could be a grant pursuant to proceedings under section 25(1), pre-grant opposition. Still the grant happens under 43. So, the grant of a patent, regardless of under pursuant to which proceeding the grant happens, the power to grant happens under section 43. Where an application for a patent has been found to be in order for grant. So, this is the word. You will find this language appearing in various provisions. So, in various provisions of the Act and the rules, you will find that the status of an application, that it is made ready for a grant or it is found to be in order for a grant, appears in various provisions. This is only to say that the application has no other objection but it is ready for a patent to be granted. We just saw in section 37(2) states that where a complete specification filed in pursuance of an application for a patent for an invention in respect of which directions have been given under section 35 is found to be in order for grant of a patent. So, this phrase appears in many places in the Act. So, it is found to be in order for a grant, and either the application has not been refused by the controller by virtue of any power vested in him by this Act. For instance, he has not refused it under section 15, or he has not refused it pursuant to proceeding under section 25(1). So, the controller has not refused, or the application has not been found to be in contravention of any of the provisions of this Act. It is not found to be in contravention of section 21(j), it is not found to be in contravention of section 10, it is not found to be in contravention of any other provision of the Act. Then the patent shall be granted as expeditiously as possible to the applicant, or in the case of a joint application to the applicants jointly, with the seal of the patent office, and the date on which the patent is granted shall be entered in the register. Subsection 2 says that on the grant of the patent, the controller shall publish the fact that the patent has been granted, and thereupon the application, specification and other documents shall be open for public inspection. So, this is the second publication. We already mentioned that an application gets published early in its life, and only after the application is published is it taken up for examination. So, publication, we saw that in a normal case it is a precondition for examination. This is the second publication. After the grant, the controller has to publish the fact that the application has been granted. There is an entry in the official journal saying that all the grant numbers will be there in that particular week. The applicant's name and the details of the invention will be there to say that the patent has been granted to such and such person. This has to be published. Once it is published, the application, specification and other documents will be open for public inspection. They become public records. Upon publication of a grant, the documents pertaining to the patent, the application, the specification and other documents will be open for public inspection. Few rules that are relevant here. Form of a patent. The patent is granted in a particular form. The form is contained in the third schedule. 74(1), a patent shall be in the form as specified in the third schedule. This is actually the certificate in which a patent is granted. It is a common form, what we call the form of a patent, with such modification as the circumstances of each case may require, and shall bear the number accorded to the application under Rule 37. Now, Rule 37 provides for sequential numbering of patents as and when they are granted by the patent office. We had already seen that. We had mentioned that in Rule 37 we are still following the numbering which started under the 1911 Act. We had already mentioned that. So, Rule 37 follows a sequential numbering. So, the patents that have been granted will bear a sequential numbering. 2. The patent certificate shall ordinarily be issued within 7 days from the date of the grant under section 43. So, the patent certificate is nothing but form of a patent mentioned in the third schedule. So, the third schedule, when it is filled with the details of the application, becomes the patent certificate. So, the patent certificate is a certificate that is issued to the patentee after the grant based on the form of a patent, which is the document in the third schedule. Third schedule has only one form, it is not actually a form. The third schedule is the form of a patent. So, it is in that form the certificate is issued. You can look at the wording, it is in that form the certificate is issued. 74(a), we had just seen that once the grant is published, the documents become available to the public. It is open for public scrutiny. Inspection of documents related to grant of a patent. After the date of publication of a grant, the application together with a complete specification and provisional specification, if any, the drawing, if any, abstract and other documents related thereto may be inspected at the appropriate office by making a written request to the controller and on payment of fee, and may obtain copies on payment of fee specified in first schedule. So, it becomes open. Now, this provision mentions appropriate office, but now with e-filing you should be able to get a copy from any of the patent office, because e-filing there is a centralized processing that is happening now, and earlier applications were known by the appropriate office designation, CHE for Chennai, MUM for Mumbai, DEL for Delhi, though that is now gone. So, they have a common numbering. If the patents are filed through e-filing, the rates are not only cheaper, it also allows a common system, and we can see that there is a trend that it will soon move towards a centralized prosecution mechanism. And the fact that the patent office now allows video conferencing will get to show that you could file a patent anywhere in India, you need not be where the patent office is, and you can also prosecute it, because now your prosecution will be through by way of call conference or by video conferencing, because that is now a part of the new amendment. So, all this tells us that the patent filing and prosecution, the entire process of filing and prosecution can be done online without physically being present. Even hearing can be done, the hearing can now be a Skype hearing. It is quite possible because video conferencing is something that has been introduced recently. 43, again coming back to it for a moment, earlier there was a concept called sealing of a patent, that once a patent is granted, the controller shall cause the patent to be sealed with the seal of the patent office, and the date on which the patent is sealed shall be entered into the register. This was an old English tradition. The patent office, if you look at the amendment to the act, this was introduced in 2005. So, before 2005, if you have access to the wording of the section before 2005, you will find that this was called grant and sealing of patent. Now, it is only called grant of patents. Earlier it was called grant and sealing of patent. So, sealing was putting the patent office seal, and the date of sealing was entered into the register. Now, sealing is completely removed, though the word sealing still appears in the chapter on compulsory license. The sealing is removed, and what is entered is the date on which it is granted shall be entered in the register. So, the date on which it is granted is entered, not the date on which it is sealed. So, the sealing has been removed, it is no longer relevant. Section 44, amendment of patent granted to deceased applicant, where at any time after a patent has been granted in pursuance of an application under this act, the controller is satisfied that the person to whom the patent was granted has died, or in the case of a body corporate, it has ceased to exist before the patent was granted. The controller may amend the patent by substituting the name of a person to whom the patent ought to have been granted, and the patent shall have the effect and shall be deemed always to have the effect accordingly. When a person dies, the Patents Act has a provision by which the successors of that person can be included as the patentee. Now, this is done by an amendment, because the patent has already been granted and you are making a change to the person who is the applicant. Now, there is a change in the status of the applicant. Now, this can happen if it is an individual, then the person who inherits from that person, the successors, will be shown as the new patentee. If it is a body corporate, if it is a company which has ceased to exist, it has gone out of business, it has become bankrupt, or it is merged into a new entity, the patent will continue in the name of the person who is entitled to the interest of that company. Now, 44, the relevant rule is Rule 75. The application under section 44 for the amendment of a patent shall be made in form 10 with substantiating evidence and be accompanied by the patent. Now, if you look at Form 10, Form 10 is for the amendment of a patent. Now, while filing Form 10, you will have to also file documents as to how you are claiming an interest in the patent. So, some evidence is required, substantiating evidence, which has to be filed along with the Form 10. Now, the point to note here is when you amend the name of an applicant who has passed away, then the amendment is using Form 10. If you generally amend a complete specification, then you will use Form 13. So, the title of both the forms are application for amendment of a patent, but Form 10 is used when there is a death or when a body corporate ceases to exist. Whereas for any amendment generally, like you need to amend the claim or you need to amend some part of the specification, you will use Form 13. Form 13 is the one which will use for amendment under section 57. So, though both these forms are titled similarly, both of them are titled application for amendment of patent. The Form 13 is titled application for amendment of application for patent. So, very similarly titled, but Form 10 is used where the person to whom the patent has been granted, the patentee has died or the patentee has ceased to exist. It was a body corporate, it has ceased. So, there is a death or there is the legal entity has ceased to exist. Only in those cases will you use Form 10. In every other amendment of the complete specification, you will be using Form 13. Date of a patent. Section 45 states that subject to other provisions contained in the Act, every patent shall be dated as of the date on which the application for the patent was filed. So, date of the patent under the Patents Act is the date on which the patent application was filed. The date of every patent shall be entered in the register. Now, we saw that the date of a patent is the date on which the application was filed, the filing date, that shall be entered in the register. Notwithstanding anything contained in this section, no suit or other proceeding shall be commenced or prosecuted in respect of infringement committed before the date of publication of the application. Now, we saw that you can file an infringement suit soon after a patent is granted, because you need to show the patent certificate for filing a infringement suit. Now, you could file for acts of infringement committed before the date of grant, but after the date of publication, because anything done before the date of publication, the person who committed that infringing action can take a plea that I didn't know anything about the existence of the patent. So, that is a defense for a person to say that I did not know the patent existed, because notice of the patent comes to the public only on publication. So, those acts which an infringer did before the date of publication cannot be a cause for grievance. That is what 3 tells us, that no suit or other proceeding shall be commenced or prosecuted in respect of infringement committed before the date of publication of application. So, though your date of patent is from the date of filing the application, between the date of patent and the date of publication of the application, the acts done by a person, they will not amount to infringement. So, the date of patent is the date on which the application is filed. From there, the first publication happens, what we call the time for publication of application, TPA. The date of patent till TPA, any act committed by an infringer will not amount to infringement. So, from the date of publication, you could ask for damages. If a person commits infringement, if he is put on notice and if he continues with the infringement, from the date of publication of the application, you could ask for damages, but you will only ask for damages when you file an infringement suit, which will be at the time of grant. So, because patent law goes back in time to grant certain rights and privileges, the ability of a person to file an infringement suit comes only at the point of grant. But at the point of grant, he could file for acts done by the infringer after the patent application was published, because only then you can say that the infringer had some kind of a notice. Any act done before the publication of application cannot amount to infringement. Section 46, Form, Extent and Effect of Patent. Every patent shall be in the form prescribed and shall have effect throughout India. Now, Rule 74 gives us the form of a patent. We have already seen that. That is third schedule. 46.2, a patent shall be granted for one invention only. We had seen that if there are more than one invention, the controller can ask the applicant to file a divisional under section 16, provided that it shall not be competent for a person in a suit or other proceeding to take an objection to a patent on a ground that it has been granted for more than one invention. Now, in any proceeding, either before a controller or before a high court, you cannot raise an objection that the application or the patent has two inventions, because it is something that can be corrected at any time. The controller will ask the invention to be split into two different applications. So, that cannot be a ground for objection. Say, you cannot ask for a revocation of a patent, or you cannot say that I am not infringing because this application has two inventions in it. That cannot be a ground for objection. It is a procedural thing, it can be rectified, and that cannot be a ground for objection in any case.